moderator for this session would be Shantanu Mohanpuri. Shantanu is one of the most well-known corporate lawyers in this region. He has remained a hardcore litigator and has done his LLM from the School of Oriental and African Studies in London under the prestigious Felix Fellowship. And he has specialized in international trade law. After doing his LLM, Shantanu returned to Chandigarh and has started a boutique law practice specializing in cross-border corporate and commercial law. I'll ask Shantanu to introduce the panel and take it ahead, please. Thank you.
Good afternoon, everyone. I think it's a very appropriate topic for an event like this, something which is relevant to most of you people who would have started out on new ventures or are considering to start on new ventures. We are here just to share our views, our ideas, answer some basic issues you might have. And for that, I have two very distinguished, young and promising lawyers. The first is Mr. Kapil Arora, who is a partner at a law firm in Delhi called Universal Legal. He primarily specializes in litigation comprising of commercial law, energy, power, real estate, as well as the gambit of civil and criminal laws, which are operational in India. Mr. Arora heads the litigation practice. He's based in Delhi, but he travels to Chandigarh because I gather they have an office here as well now. Amongst his various areas of work, he's been contesting matters as high as the Supreme Court and in diverse forums as tribunals and district courts. So procedurally, he's quite sound and he can, I'm sure, address issues which people might have regarding delay, injustice, or, for instance, enforceability of contracts and so on and so forth. Also with us is Mr. Jitin Talwar, who's a partner at Talwar Associates, Talwar Advocates, and a consultant with Talwar and Talwar. His background is that of an engineer, but he has polished up with a degree in law, which enables him to be a good source for intellectual property right related issues. He has tremendous experience from his area of work. He's been advising Indian companies on patent strategies. He's been doing cross-border work pertaining to US companies, Asian, South Asian, East Asian companies. He's also been involved with other areas or emerging areas, automobiles, wind and solar, power, telecom, software, integrated circuits, and so on and so forth. So something which some of you might have interest in. We're trying to make this session primarily address two concerns. One is, which I feel is relevant, and as do my co-panelists, is that IPR is always a very touchy topic, especially in a country like India where IPR has not really been dealt with seriously ever. Nobody really felt the need that IPR was something which was important till we entered the 22nd century, or 21st century. With newer businesses coming into India, investments coming into India, nature of businesses in India being across the globe, I think IPR is something which is very relevant and would especially make a lot of sense to a lot of people here who are starting out in businesses, as I mentioned. With that, we intend to address issues which you might have. So we'll split this session up into three parts. My co-panelists will address you individually for a while, and then after that it's open for a Q&A. So with that, I'd like to invite Mr. Kapil Arora to start up with this session.
Hi, good afternoon, everyone. To start with the IPR issue, what every startup would look at. First is you're starting a company, you've started a logo, a brand name which you will establish in the coming years. So to start with, I guess, you should register your trademark, your copyrights and everything. I'll not take much of your time on addressing trademark and copyrights. Jatin is here, he masters everything, so we help you out with that. How do you register a trademark, copyrights and other issues? The second important point is when it comes to IPR and other issues, how do you enforce it? Supposedly you have a trademark registered and somebody else is using your trademark. What is the enforceability? How quick you can get to the court and what other relief you can seek from the court. Supposing you have Thai as a trademark or Try as a logo. If somebody else tomorrow starts with a firm by the name of Thai, so what should Thai do to stop it? The first thing is they can file a suit for injunction, and on the first day, depending upon the jurisdiction, there's 90% chance that you'll get ex parte stay from the concerned court. If you are able to prima facie convince the court that Thai has a registered logo and guy has been using this over several years. So on the first day itself, you'll get an injunction order from the court. That is normally what other people or the person who has never seen the court, they feel is that once you approach the court, it will take years to get the decision. But the injunction is one issue which you'll get on the first day itself. If you are prima facie able to convince that you have been using this and you have been using it for the past so many years and you have a registered trademark or you have a registered logo or your copyrights are well in place. Second thing is once you start your company, I guess 90% of the people here are looking for IT companies. So one of the major things what all IT companies should work on is the NDAs, which is known as non-disclosure agreement. If somebody, one of your employees there, whom you are sharing your innovation, your services, your product, and tomorrow if your employee shifts from one organization to another, they may go to your client base, your innovations, so how you can secure that. To secure that, we suggest all our clients, we work a lot on IT issues. Our firm is the only firm which I'll say which have 5 offices in India and we have 5 offices in US, so we work closely with the IT sector across both the countries. And 70% of US clients are from IT companies. So what you need to get in place for an India is you should define what is the scope of services, what is the innovation, what is the company which is company's details, whether it is client base, whether it is innovation, whether it is the data, whether it is the product. 90% of the employees, they make a software during your the services of the company. So the issue is whether that software belongs to that employee or whether that software or the product which has been done belongs to the company. So as per the law, it says if your NDA is in place and your NDA says that whatever product he has innovated during the services with the company, that product belongs to the company. And with regard to the enforceability, as per our Constitution of India, you cannot restrain anybody from business. You cannot say if you are working with me tomorrow, you cannot work with X or you cannot work with Y. But there is a specific timeline where you can enforce this. That supposing if you are working with me for next 3 months, you cannot work with him. So that part of the thing is which can be secured by law. But you cannot restrain him forever because this is barred by our Constitution of India. That is freedom of business, freedom of trade, you cannot restrain him. Apart from this NDA, the third main issue what you need to think is before starting off is whether you want to do it proprietary concern, whether you want to do partnership concern, whether you want to launch a company. In my opinion, the best thing is to start a company. You can make your company XY Limited, whatever the scope of the work is. Supposing you have an IT concern, you can name Aman IT Research or whatever it is. And it will not take more than 10 to 15 days to register a company with ROC. And in case your company is registered with any of the ROCs, the legal formalities are much in place as compared to a proprietary interest concern or the partnership concern. Because 90% of our startups looks at tomorrow if somebody wants to invest in your company. So if you have a proprietary concern or partnership concern, the investor may have some issues before investing. Any investor would like to invest in a company, not in a partnership concern and a proprietary concern. To register a company will not cost you more than 50-20 grams, and the share capital you can start with is 1 lakh shares. So once your company is in place, you just need 2 directors. That can be anybody from your family. And in India, there is no bar if any foreign national you want to introduce as a director, they can be a director. The only thing is you require a DIN, that is director identification number, and your digital signatures. And you decide on a name, you can do it online, you don't need a CS, you don't need a lawyer for all this. If you're well versed with the internet, you can do it yourself. And depending upon the share capital, there is a nominal fees. For a share capital of 1 lakh rupees, there is a nominal fees of 5,600 rupees. And once your company is registered, the company has to follow all the laws as laid out in the Companies Act. You have to file your returns, you have to file your director isn't there, so each and everything form is there. So tomorrow if you're looking for some venture capitalist or some equity, so it is always prudent to start a company at the initial stage. You can increase your share capital whenever you want. From 1 lakh you can take it to 1 crore, from 1 crore you can take it to 1,000 crores, there is no problem with that. So I guess this is one important thing which all should consider before starting a venture. Because from the day one, if you have started a company, your all documentations are in place because it is mandate under law that you have to do your filings. So tomorrow if somebody wants to invest in, they'll just see all your filing is in place. So they'll not have any hassle to look into your company details, whether your share capital, who is holding, what is the amount of shareholding, then you can convert your share purchase agreements. So everything can be routed through if you have started your company in place. So I guess these are the primary three things what a startup should consider before starting this. So I'll pass on to Jatin to give you some insight on trademarks and other copyright issues.
Thanks, Shantanu, and thank you, Kapil. I totally second what Kapil said that as a startup you should start with a company. I myself have been closely associated with a services startup. We always, as lawyers, whenever you start off, you're always a startup. So it's important to protect as well as be aggressive about what you're doing. So the first thing that any startup encounters is what's my name. If you go and get your company registered, there is an ROC procedure, and usually you can get around the ROC and tell them that you want this name, that name. They might even give you a name. But the fact that you have a name from the ROC does not mean that you have a registered trademark. There have been so many companies that I've dealt with, there are so many clients that have come in from time to time who have had very, very sane names, something like an Ascent or a DCSL. These are actual cases. But what happened was thereafter when they started working in a practical environment, the real TCS or the real Essential came in and came back to attack them saying that no, hang on, you may have a name from the ROC but you're still infringing my trademark. So it's important to, when you start off, to do your due diligence properly. I know the energy of a startup, the energy of starting up, you don't want to really care about what's happening, but the problem really comes when you've really grown and you're well on your way, and then these people come in who are waiting to come by. So it's important to have to start with the right note, to have to just do some due diligence, do some Google searching, do some just a broad search, and see whether somebody or the other has a trademark which is similar to what your name is. When I say similar, you cannot also do a name which is deceptively similar to somebody. For example, if somebody is running a company called Accenture, you can't have a name called Accent. That's not allowed because your name is deceptively similar to somebody else's name. Why not have an original idea and go forward with that in as far as your name is concerned? Intellectual property can be again divided into trademark, patents and copyrights. These are broad three classifications. There are geographical indications, integrated circuits, others which they are not of concern right now. Software per se is not patentable in India. You need to protect it in a different way. The general rule is that whatever intellectual property you have, or whatever intellectual abilities that are there in your mind, and that you put down in a paper, either in the form of a website, or in the form of an idea, or in the form of a product. The major idea is that everything should be and can be protected. And once you take your idea to the market, it is and you're dealing as a startup, you're dealing with employees, you're dealing with companies who have bigger financial muscle. So the moment your idea becomes or starts becoming a little successful, you will see first of your employees starting to tell you that okay, I have I can also start this, or they'll start looking at how the startup has started growing, but I need to now branch out. So it's very important to have a cat in the bag. When I say cat in the bag, what does that cat have? the cat should be armed by an NDA, which my friend Kapil told you about. That NDA should be strict. I'll give you an example of what happened. In one of our clients' NDAs, there was a stamp paper and a very nicely worded NDA, but most of the clauses of the NDA talked about that the person cannot leave the company and join another company which is a competitor. And first page of that NDA was not signed. So, I asked him what happened. He said, I had given it to my HR. So I prepared the NDA, got it done from the employee, but the first page was not signed. So it's a combination of inexperience plus the process is not being in place, and it happens in a startup. So you've got to be careful that these cats in the bag are very important, and you may not notice them, but your employees do notice them. They always know, and then when you tell them that, okay, I'll enforce this NDA because you're leaving me and going to a competitor, taking my intellectual property, they will come back to you and say you can do whatever you want. So it's very important to have the right things in place. What you cannot protect through a trademark or a patent, you can protect through a copyright. Anything which is broadly or loosely artistic in nature, you can claim a copyright on it. And copyright is the best way to protect your intellectual abilities. And then violation of a copyright has both civil as well as criminal. I'll say criminal with a capital C. So you can enforce copyrights much more easily as compared to patents or trademarks. In copyrights, there is a copyright board. You can go there and forward your application saying that this is my copyright, and I have these. They have very simple procedures you can follow. Copyright is again, if it's a book or if it's a literary function, remains your property for a long time. In certain cases, it's up to 60 years. A trademark registration procedure is again very, very simple. A lot of rights related to trademark vests in you automatically by common law. However, to have a prima facie right, you need to apply for a trademark. The trademark is applied at the trademark office. You need to file an application with your trademark, and a simple application. And the procedure takes about 3 years or so. However, in the meanwhile, by the time you've applied for a trademark, you can still write TM over the trademark that you applied. And once it's granted, you can write an R over your trademark. As far as a patent is concerned, if you've got a real idea, an idea which really makes sense, and you're a startup, what a lot of our US friends have been doing is just apply for a patent. And this is a kind of a business secret that I'm giving out. Apply for a patent, and then it takes about 4 years. You have about 4 years from the date you apply for a patent for it to be examined. And you have a lot of interaction, a lot of bargaining that goes on in those 4 or 5 years that the date you apply for a patent until the patent is granted. So until then, you can talk about your technology as being a patent pending technology. And then you can take that technology to investors, to venture funds, to so and so, saying that, okay, this is my broad idea. And this is what I want in the bag. And this is the patent pending technology I was talking about. So, again, the technology vests in you. It may not be novel in a lot of senses, but it is at least a patent pending technology. You have it in the bag, and you can again use it in your NDA saying that, okay, I'm using this patent pending technology and so on and so forth. So, again, the formal procedure for applying for a patent, again, you have to go to at least in the Indian Patent Office, you have to go to the Indian Patent Office, apply there. A patent agent can do that for you. The drafting of a patent is a very important process. You need to draft it, taking into account what all exists in the domain before what you've been practicing. Once you take it to the patent office, there is an examination procedure which takes about 3 to 4 years, 5 years. You can also use what you have and take advantage of the same invention and take it outside India and apply outside India as well. Once granted, the patent is in existence. It remains in existence for about 20 years total, plus minus a few years because of some official delays, etc. As I said, one more very important aspect is web domains. What kind of web domains do you have? Whether your web domain is if you have shilpashetty.com, nobody will let you use it. You've got to have a web domain, a trademark, and a company name. These are three different domains. These are three different areas.